Actually, I'll make the change and I will join in again.
Okay, team, please join as soon as possible.
Yes, yes.
Participants, please turn on your cameras. Good afternoon. Welcome to the final round of the 5th National ADR Competition 2024, conducted by the Kerala Law Academy Law College in association with the Kerala Law Academy Moot Court Society and IQAC KLA.
Are we audible?
Yes, sir, you are.
Kerala Law Academy is a beacon for outstanding legal education, scholarship, and inquiry. Internationally recognized for superior legal academic programs and research initiatives, a leading hub for transformative legal learning and groundbreaking research. It is a flagship institution of legal education, scholarship, and intellectual discourse under the visionary guidance of late Dr. N. Narayanan Sir, with a cultivated environment where students thrive in both national and international spheres, distinguishing themselves in various programs and events.
Alternative dispute resolution is a mechanism that provides an alternate method of dealing with legal issues. The lack of effective legal remedies to people in need has resulted in piling up of unsettled cases. In order to reduce the burdens of cost, the ADR system has come into play. This fifth ADR competition, organized by Kerala Law Academy, aims to provide opportunity to students to learn and explore the alternate forms of dispute resolution, which will enable them to amplify their ability and the legal language. Moreover, the competition transcends the boundaries of traditional legal education, offering participants a transformative experience that extends beyond the confines of education.
It is our privilege to have three eminent legal professionals to judge the final round of our competition. Firstly, we have Advocate Sriral Varia Sir with 35 years of standing at the High Court of Kerala. Sir has been into arbitrations since 1996 and an arbitrator empaneled by various institutions and mediator since 2004. Sir is also an MCPC empaneled mediation trainer, a certification that demonstrates his expertise in mediation training. Currently, Sir is also the Senior Standing Counsel at the High Court for Customs, Central Excise and Goods and Service Tax Departments, and Sir is the Retainer Counsel and Special Public Prosecutor for the CBI, DRI, and DGI. He has also worked with the international law firms abroad for several years. He has been a guest faculty at various institutions, including the judicial and other academies in ADR. It is my pleasure and honor to welcome Advocate Srilal Varia Sir to the final round of our competition.
Next, we are honored to welcome Advocate Ajit Joy Sir, a distinguished advocate in the High Court of Kerala with a specialization in constitutional law, criminal law, and arbitration. Renowned for his expertise in anti corruption, law enforcement, and anti traffic. Sir currently consults for various governments and United Nations agencies. Previously, Sir has served the United Nations as country manager in Indonesia, program manager in Kenya, and as a superintendent in the Indian Police Service. On behalf of the Kerala Law Academy and personally, I extend a warm welcome to Advocate Joy Sir as he joins us for the final round of our competition.
Finally, we have Advocate Jaikar Sir, who is a prominent lawyer at High Court of Kerala. Sir was appointed as standing counsel for All India Council for the Technical Education. Additionally, Sir was also the counsel for petitioner in Sprinkler case, thereby adding a golden milestone in his legal history. It's an honor to have you here with us, Sir. On behalf of Kerala Law Academy and on behalf of personnel, I would like to welcome you, Sir, to the final round of our competition.
The forum officers for this session will be Sena Fatima, Anaga Sunil, and myself, Govindas Vaidyan. We would be guiding you throughout the session. Judges, with your kind permission, shall we start the briefing session? Judges? Judges, am I audible to you?
Are we audible?
Yes, sir. There is a bit of reverb, but you are audible.
Fine. Yeah, fine. That's okay.
Srilal, sir, am I audible to you?
Oh, yes. Start. Hello. Yeah, we're trying that. Okay. Sure. Clear അല്ലെന്നാ അതിൽ നിന്ന് കയറണം. So we'll do one thing. Yeah, cut it.
Participants, please hold on for a moment. There seems to be a technical difficulty with the judges.
UP കേട്ടോ. അടിപൊളി. Yeah. Can you hear us? Okay. Can you hear it? Okay. Oh my God.
Sir, am I audible to you?
Yep.
Okay. Thank you, sir.
Started.
Okay. We are once again welcoming the judges. We welcome Advocate Srilal Warrior, sir, Advocate Ajit Joy, sir, and Advocate Jaika, sir, to the final round of the 5th National ADR competition. The, fo- the forum officers for this session will be Seina Fatima, Anaga Sunil, and myself, Govindas Vaidyan. We would be guiding you throughout the session. Judges, with your kind permission, shall we start the briefing session? Judges?
Please.
Thank you, judges. Claimant, please unmute your mic and state your team code.
Our team code is Team A.
Team A. I repeat, your Team A.
Yes.
Okay. Responding party, please unmute yourself and state your team code.
We are Team K.
Okay. Rapporteur 1, please state your team code.
Team code K.
And Rapporteur 2, please state your team code too.
Team code H.
Okay. Thank you, participants.
Can you repeat, please? Just once.
Yes, sir. The claimant is team code A. The responding party is team code K.
Okay.
The rapporteur 1 is also team code K. And the rapporteur 2 is team code H.
Thank you.
You're welcome, sir.
Candidates may please note, I'm going to read the rules. The total time allotted for the competition is 40 minutes. At the end of 40 minutes, an additional 10 minutes will be provided for the feedback as per the discretion of the judges. At regular intervals, the court officer will be giving you a verbal intimation as to the time remaining. The participants are to keep the video on at all times throughout the meeting. Thank you.
Judges, I kindly request to note that there will be a 10-minute feedback session. The feedback session will begin after the verbal intimation by the court officer. At the 8th minute of the allotted 10 minutes, a verbal intimation will be given. Thank you.
Judges, with your kind permission, shall we start the session? Okay.
Can we start the session?
Please.
Yeah.
Okay,
This
thank
is
you.
the finals with team code A as claimant, team code K as responding party, team code K again as rapporteur 1, and team code H as rapporteur 2. The participant may please note the session starts.
Good afternoon to everyone present here. I am honored to serve as your arbitrator today. I am a certified arbitrator with over 10 years of experience, and my role is to be impartial and give a binding award after assessing the arguments of the parties.
So a pleasant afternoon to all present here. I am arbitrator to the dispute at hand, along with my co-arbitrator. We are here to help resolve the dispute by way of arbitration. We'll be assisting the parties to do so.
Before we begin, I call upon the parties to introduce yourselves. Claimant, you may start with your introduction.
Am I clearly audible right now?
Yes, you are.
Yes.
Greetings, everyone. I am Harvey, the current manager of Blagona FC, the football club, and I am responsible with the club's football strategy, the player development, and their performance across all competition. I am present here today with my counsel, and we are representing Blagona Football Club and we are open to considering resolutions that can be achieved in a fair and in an impartial arbitration process. Now, I would pass on the baton to my esteemed council member to introduce herself.
Greetings, everyone. My name is Eshnare. I am the legal representative of BFC. As we all know, arbitration is a powerful means of resolving disputes within the disputants. I'm really glad to the arbitrators who already established their economy neutral, which is very important for this process. And I hope the whole process is becomes a winsome gain for both the parties. Thank you.
Respondents, you may go ahead with your introduction. Am I audible? Yes.
Yes.
Thank you, esteemed arbitrator. Good afternoon, esteemed arbitrators. I'm Chinmayi Hegde, and I'm the counsel representing the Global Football Federation, the GFF, in this particular case. To further support the interests of the Federation, I'm accompanied here by the Vice Chairperson of the GFF, Ms. Bella Salvatore. I would first like to thank the arbitrators for giving this platform and also thank Logana FC for accepting this mode of dispute resolution. I'd also like to mention that I do not have any authority to make decisions on behalf of my client. I'm here to ensure that the best interests of my client are conveyed to the arbitrators and that the decisions made by the arbitrators are understood and accepted by my client.
Honorable Arbitrator and representatives of Blogana FC, I'm Bella Salvatore, the Vice Chairperson of Global Football Federation, and I'm grateful for being able to present the position of Global Football Federation in this present dispute.
Thank you, parties, for your introduction. So now I will be explaining what is arbitration and its merits. So arbitration is one of the alternative dispute resolution mechanisms in which parties through an agreement try to resolve the dispute in an amicable manner without the need for it to be solved in a court. And here the parties agree to be bound by the decision which will be given by the arbitrator. So such decision is called an award being enforceable by law. So now I would like to highlight the key merits or advantages of arbitration. That is, arbitration is a flexible and a speedy process compared to the complex or cumbersome procedure of regular court. And arbitration is less expensive and accessible. Neutrality and mutuality is maintained at par in the arbitration. So arbitration allows the parties to keep the matter out of public reach, and indeed it protects the reputation of the parties involved in the dispute. So now I assure the parties that we, being arbitrators, are not prejudiced to any party, and we are unbiased, independent, neutral, and impartial throughout the session. We'll be listening to the arguments of both parties and come up with a solution at the end. So parties can note that our decision shall be binding and has the same effect as a court's judgment. So before we start, I want to know whether the parties present here have the authority to take decisions.
Yes.
Yes, yeah.
Okay, thank you, parties. So I hope this session will turn out to be a productive one in order to resolve the dispute. So over to my co-arbitrator.
Thank you, arbitrator. I would now like to proceed by setting some ground rules that must be followed. Firstly, I ask both the parties to maintain decorum throughout the session. Please refrain from using any inappropriate or unparliamentary language and have a respectful communication. This is a private and confidential process, and no details shared here may be disclosed to outside parties. We are here as a neutral decision makers. Both parties should refrain from any private or ex parte communication with us during the proceedings. Before we proceed, let me reiterate that we, as arbitrators, are impartial and our focus is on evaluating the case presented to us in an unbiased manner. Our decision at the end of these proceedings will be final and binding on both the parties. With that being said, we will now move on to opening statements. The claimant, you may proceed with your opening statement.
Oh. Thank you to the panel of arbitrators here today. First of all, I would like to extend my greetings to everyone present here, to the esteemed judges, to the esteemed panel of arbitrators, and also extending my warm regards and greetings to Ms. Bela Salvatore, the Vice Chairperson of Global Football Federation, to be present here along with her counsel. Uh, from me and my counsels, from both of us side, we are respecting the arbitrator's understanding and their explanation that has helped us to understand this process and the session a lot better, and we hope to reach a resolution. Now, I would ask my counsel to start with her opening statement.
Yes, the understanding has been really crucial for these proceedings. I must say, there are always two truths to a situation. There are frictions, that's why we are here, but we all are here to find a amicable situation for which we have to find a settlement to which will end up to be a award. We must find a way to move forward. On this note, on the behalf of the client and myself as his counsel, I would like to request the panel of arbitrators that I would like to put forward our respective issues in complete manner at a go if it's if permissible by the arbiters.
Yes, you may, counsel.
I would like to also mention that after the opening session and the facts, we also like to state the jurisdiction and then come to the issues to clear the proceedings, mannerism that we are proceeding.
And now seeking permission from the panel to start with the background of the case, if the panel of arbitrators would allow me to state the backgrounds.
You may proceed.
So before that, I would just like to say that I wanted to say that I am just a normal human being here. I don't have any legal background, so all the technicalities aspect of it, all the laws would be dealt by by the council that we are representing BFC in general. So we are here today, now starting with the background of the case. We are here today to address a matter that is both a challenge to a club or to a player in general. Now, touching on this issue is much more of a larger impact in the international football because it talks about the protection, the welfare of the players in general, the responsibilities that an international federation such as Global Football Federation is holding. Now, to begin with such an unfortunate incident is that in a transfer window, we brought Pedro Gonzalez with almost over 100 million euros, an extraordinary talent who joined Blaugrana FC. And we had very high hopes and expectations for the upcoming season. But I should fairly point out at this stage is that Gonzalez was not just another signing. He was meant to be the cornerstone of the club. He was the star player of the club. Yet, as they state that there is always a cruel twist in fate, while Gonzalez was representing his national team in an international match against Germany in one of the competitions held by GFF, he suffered an ACL injury, and that on sidelined him and effectively ruling him out for the entire season. Now, this is not merely a setback for Gonzalez, but also for us, for our club in general, because we have heavily invested in the player. The player joined us. We were awaiting his arrival with all the training and conditioning and medical test procedures that were there. We were aiming to compete in competitions of the Hispania Football League competitions, the domestic football competitions, the international competitions. And this cost of injury of our star player has caused us immense financial losses, but also a missed opportunity of success. Now, if I talk about a hypothetical scenario, if we talk about star players, such as, for example, if we talk about someone like Lionel Messi or Cristiano Ronaldo, if we're talking about now, losing a star player has a catastrophic impact not only for the club, but also for the entire event as a whole, entire footballing event or a footballing competition as a whole. It affects the fans, it affects the sponsors and overall spectacle of the competition. Now, in football clubs, we invest millions and millions of dollars or pounds in each and every player for their training, for understanding their player, for developing a strategy to move forward in each and every competition. So when a player is injured at an international duty, it is us, the club, that we are bearing the brunt of the financial and competitive losses. It can be fairly stated that the relationship between a club and the or international team or the national team that the players are representing has been a very delicate balance. While players are proudly presenting them at the national level, it is the club, us, that are shouldering all the financial risk associated with it. Now, pointing out on the aspect of the negligence that has been caused, the negligence was caused, first of all, on the part of the national team's medical staff who alleged we are alleging that they failed to properly assess Pedro Gonzalez's fitness for the match against Germany. It was no secret that modern football is much more intense in physical aspect of the players. The role of the medical teams should have been important in ensuring a fit and a complete one. With the responsibility being neglected, the consequences are disastrous as we are seeing in front of us right now. But it does not stop there. The Global Football Federation, as the governing body, also has a duty to protect the players who represent their nations. Now, Brogan, we contend that the regulations for the player protection insurance for the international duty is very much inadequate that is provided by GFO. Therefore, we are right now present in front of the panel of arbitrators in the Court of Arbitration for Sports, arguing for us to compensate for the financial losses that we will suffer because of the absence of Gonzalez and also the cost of the temporary replacement and potential loss of revenue. Now, I would ask my counsel to move on with the jurisdictions of the issue.
The club submits that jurisdiction of CAS derives from the Article 49 of the FIFA statute. The dispute resolution in football. The Court of Arbitration for Sports (CAS) is based in Switzerland, handles disputes in sports in footballs. CAS is an expert in sports law and provides a faster way to resolve disputes comparing to going to a court, ensuring fairness and proper governance in sports. Now, as this case includes a dispute within a club against another member of GFF and FIFA itself, the club submits the formal requirements are met to the jurisdiction of CAS. Furtherance to it, Article R59 of the CAS Court read with FIFA Statute Article 49 subsection 2, CAS resolves disputes based on the rules and regulations chosen by the parties. If no law is chosen, then the panels applies the laws of the country where the sports body, that is FIFA, is based, which is typically Swiss law. However, the football disputes CAS primarily applies FIFA rules, which supplements them with Swiss rules when needed. This ensures the disputes are resolved fairly with a focus on maintaining the integrity of the sports. Now, seeking the permission of the panel to start with the following issues.
You may go ahead, counsel.
Indeed. Now, the first issue that we would like to highlight was what is the negligence on the part of national team medical staff. Now, for the more understanding the background of this issue, I would like to ask my client to explain the same.
Thank you, counsel, and also thanking the panel of arbitrators for allowing us to proceed with the issues. So, the first issue, as stated by the council, was on the negligence on the part of the national medical team. Now, as we are here presenting our case today, our focus is on the pivotal issue of negligence that has profoundly affected us and concerning the national team's medical staff role in the case of Pedro Gonzalez. While it is true that Pedro has joined our club, but he did not play any of the matches for us because we were waiting for a smooth transition from the after we brought him in the winter transfer window so that he could join us effectively. And there are some training procedures, the conditioning procedures, the health aspect, and the medical test. Everything would be going on in a very smooth and an effective manner. But however, as I stated earlier in my facts, that there was a dramatic turn that happened, and there was this ACL injury due to which the sidelining happened, and therefore we were not privy of the potential issue of this of Pedro's fitness. Now,
Mr. Client, I'm so sorry for
yes.
interrupting. Could we please finish the opening statements of the respondent and then come back to the issues?
Yes, absolutely, absolutely.
Sure. I request the respondents to start with their opening statements.
Thank you, honorable arbitrators. Firstly, I'd like to thank the honorable arbitrators for beautifully explaining the rules and laying down the ground rules for this session. I'm here today representing the Global Football Federation, hereinafter referred to as the GFF, which operates as the governing body responsible for organizing and overseeing international football competitions under clear and established protocols. This arbitration arises out of an unfortunate injury suffered by Mr. Pedro Gonzalez during an international match. At this juncture, it is imperative for me to state that Pedro Gonzalez was playing for España, which is a national team, and España's national team was alleged negligence for not assessing Mr. Gonzalez's fitness, and GFF has nothing to do with it. But we do acknowledge the severity of the injury of Mr. Gonzalez and fully sympathize with both the players and Blogana FC for the impact it has had on them. However, the GFF maintains that it has complied fully with all regulations and protocols established under its governance to ensure the safety and well-being of players during international matches. We'd like to make it clear that the responsibility for player fitness and medical care, especially regarding decisions related to match fitness, lies with the national team's medical staff. Further, the GFF has a very comprehensive player protection mechanism, including the Player Protection Insurance Policy, which provides specific coverage in such cases. So, Blogana FC's claim that these measures are inadequate is without merit, as GFF has met its obligations under these provisions. Furthermore, the claims of losses suffered by Blogana FC due to reduced ticket sales, sponsorship losses, or viewership losses cannot be compensated by GFF, as these elements are not indemnified in the player protection insurance. The transfers, signing a replacement, and other losses relating to it are purely contractual to which GFF is not a party. We are here to respectfully defend against the claims of negligence and to affirm that the GFF's policies are consistent with international standards and have been applied diligently. We seek a fair resolution to this dispute based on the facts and the applicable regulations. Should it please the arbitrators, the client, the Global Football Federation would appreciate the opportunity to present their perspective directly. The vice chairperson of the GFF, Ms. Bella Salvatore, would like to briefly share her side of the case.
Yes, please.
I would like to take this opportunity to first put on record that the GFF always maintains a required standard to ensure fair play, safety, and integrity in all its games. And this is a standard that GFF takes very seriously and ensures to take all necessary steps to ensure it's implemented. And the same was taken during the match of Hispania versus Germany, where the unfortunate incident of the Germany to where the unfortunate incident of the injury to Mr. Pedro Gonzalez occurred. One needs to take note of the fact that a sport as competitive as football, injury is an integral part. Injury can happen in such a sport, not belittling or undermining the fact of the injury. However, GFF cannot be made liable to the same. The GFF has a very comprehensive player protection insurance policy, which states that a player's absence can be indemnified. However, any additional cost associated with it is unforeseen. And if such losses were to be indemnified, it would set a very dangerous precedent, because any and all losses arising out of the absence of the player would have to be then indemnified by the GFF, which then which threatens the integrity of the game. So GFF should not and cannot be made liable to the injury sustained by Mr. Pedro Gonzalez. However, we sympathize and empathize with his injury, and we're ready to indemnify him for his leave of absence and his medical expenses. However, the loss of sponsorship or ticketing sales cannot be indemnified by GFF. Thank you.
Thank you, respondents. If it pleases both the parties, we may go ahead with the issues.
With the permission of the arbitrator, could I please complete my issue that we were stating in just a few?
Yes, you can.
Yes.
Thank you to the panel of arbitrators. So, as I was talking about mentioning the issue about the negligence on the part of the national medical staff, and as I stated that this situation, this dramatic situation that occurred during an international match that sidelined one of our star players, for which we are now incurring financial losses. And we were not even aware of any prior issues that were concerning to Pedro's fitness. It was after the injury that I, along with the medical staff of our club, we went ahead and who obviously the medical staff of our club has 27 years of experience in this sports related, according to any sports related injury, who examined him thoroughly and confirmed that the diagnosis of the torn ACL and that there was no professional assessment that was being done, and the seriousness of the injury also indicated that a proper treatment would be there. Now, moving on with the second issue that I was about to be discussing was the liability of GF. Now, at the heart of the argument is the assertion that GFF's significant liability is for the financial and competitive loss that we are suffering because of the direct result of Gonzalez's injury. The action or the lack thereof from the GFF and its medical staff has created a situation that led to this substantial setback. There is always a duty of care that GFF has to ensure the health and safety of the players that are representing in the national team. The federation is always under the governance of the GFF. It encompasses the clubs that it is always upon us because we are investing heavily. The clubs are investing heavily for the development and well-being of the player. But if at the end of the day, if I'm not able to, use my star player for any of the competitive matches, the loss is on us. That the bearing of the loss is what we are suffering. GFF has the responsibility to conduct comprehensive fitness assessment and provide accurate information to us before even allowing him to participate in the international matches. I can understand that the federation usually conducts all these medical instances or the medical tests about it, but the reports are obviously shared with GFF, so they have been aware of it if there was any potential injury that was existing or not. Now, there has been at the very end, I would just like to end that the evidence presented or the inadequate medical oversight was obviously there. As I stated earlier, that along with the medical staff who were veteran in the sports opinion, they stated that the player, there was no proper medical treatment that was provided to the player. There was this lack of thorough medical evaluation before the match, and that not only endangered Pedro's health but also placed us at a significant risk. And there is obviously a financial and a competitive impact that we have to incur, and that includes the salary along with the recovery, the cost associated with the signing of a temporary replacement. Now I would just invite my counsel to further assess this on the impact of the technical aspects of this.
Yes, to clarify, the evidence that was talked about by my client is the twofold evidence. That is, firstly, the medical reports from the physician outlining the extent of the injury and the necessary treatment, and secondly, being the MRI scans that results confirming the ACL tear, which is a ligament tear, which was obtained immediately after we became aware of the situation. Now, the basic question, the fundamental question that comes, why did this ACL tear occur? The answer lies in the negligence of the national team's medical staff, who failed to provide adequate pre-match fitness assessment like it was established previously by my client. They did not communicate any underlying issue that may have compromised Petro's ability to compete safely. Now, I would also like to mention the contract we entered into by my client was predicated on the assumption that the player was fit and was ready to contribute to our club. By neglecting their duty of care and allowing Pedro to participate in a high-stake international match without any proper medical oversight, the nation's medical team not only jeopardized his health but also compromised our club's investment and competitive prospects. BFC had no knowledge whatsoever of any medical issues that could have prevented Petro from playing, and it's precisely this lack of communication and due diligence that constitutes negligence on the part of national team's medical personnel. On this point, I would also like to mention that there is a difference between signing and arriving. It is true that the player has already signed the contract and was very well doing, but there is a window period like my client already established, so that the Pedro was performing another match. And when we got to know about the injury, we just gone there and did all the medical reports, hence the evidence of medical report from the physicians and the evidence from the MRI. After knowing that, we got to know this, there is a ACL tear. If we had been known this situation previously, it would have, maybe this situation would not even occur. Hence, all the negligence is on the medical team.
The participants may note that you have 15 minutes left.
Thank you, Clemens. I consider this as issues and arguments since you included your arguments as well in the same. I would like to ask the respondents to go ahead with their issues slash arguments.
I'm so sorry to interject, mediator, but we also have another issue. If you may, if I should say right now or just wait for the opposite party?
Council, let the opposite party finish since there's paucity of
Indeed.
time, and then we can come back to you.
Indeed.
Thank you, esteemed arbitrator. I would like to go ahead with my arguments if it pleases the arbitrators.
Yes,
Yes,
can.
please.
Thank you. So first, I'd like to speak about the jurisdiction. We, the respondents, are here in front of the Court of Arbitration for Sport, as under Rule 27 of the Code of the Court of Arbitration. Under this rule, reference to the court may arise out of an arbitration contract or clause contained in an agreement. As per the separate arbitration agreement entered between Blaugrana FC and the Global Football Federation, hereinafter referred to as GFF, with the objective of resolving this dispute, we submit to the jurisdiction of this Court of Arbitration. The council, on behalf of the respondents, would also like to emphasize that the injury of Mr. Gonzalez was caused by a challenge from an opposing player during the match between Spain and Germany. It was caused by a challenge given by an opposing player from Germany's team. This is an inherent risk in football, which is voluntary non-fit injury, which means that there is an assumed risk. GFF, as a regulatory body, does not have direct control over the actions of individual players on the field. No evidence has been presented to show that GFF contributed to or caused the injury, and the injury itself is a result of normal play in football. And furthermore, there is no proof that GFF violated its duty of care towards Mr. Gonzalez or that it failed to uphold its regulatory responsibilities. The argument that GFF was negligent in overseeing player safety protocols or insurance provisions must be supported by specific breaches, which have not been demonstrated. There has been no specific breach that directly connected to an incident of negligence displayed by the GFF. Because there was no specific breach on part of GFF that led to Mr. Gonzalez's injury. I'd further like to state that the player's fitness and medical management falls under the national team's jurisdiction, which has its own medical procedures. In this case, it was a match between España and Germany, and Pedro Gonzalez was playing for España's national team and not GFF's national team. We would like to emphasize to the esteemed arbitrators that it is España's medical team and not GFF's medical team that was responsible for the negligence. Every medical team has its own procedures, and as stated by the claimants, they said that the medical records were given to GFF, but I'd like to state that every medical team has its own procedures, and the medical records of players are confidential and are not shared with anybody else. I'd also like to talk about the FIFA Club Protection Program, wherein the laws are discussed. The laws that are discussed in this particular case, they have similar merits, and the role of the GFF and FIFA are pretty much similar. The structure of the GFF and FIFA are also pretty similar, and that is the reason I'd like to talk about this particular club protection program. So under FIFA's club protection program, all football clubs are protected in cases of a TTD. TTD means temporary total disablement as a consequence of an accident suffered by the players during the operative time being the time where they're playing. If this prevents the football player from playing for his club for more than 28 consecutive days, then that particular club would be they would be liable. I mean, they could get the insurance that is promised by FIFA. So the compensation payments are made to the clubs for the period they employ those football players, and they only cover the salaries of the players injured during the period of inactivity. Let's say if there is a particular person who's playing and he injures himself, and for more than 28 consecutive days he's not able to play, the salary of those days where he's inactive and he's not able to play, only those things are covered. Additional losses like sponsorship sales, loss of tickets, loss of endorsements cannot be covered even under this club protection insurance, which is FIFA's club protection insurance. And the whole concept of insurance, esteemed arbitrators, it is to indemnify the losses that are directly connected to a particular event. In this case, Mr. Gonzalez's salary was contingent on him being fit and playing. Thus, only that can be covered. If the claimants add on to those losses to include other losses that are not directly related, the list never ends. Furthermore, the GFF player protection insurance policy specifically states that it does not cover additional losses and covers only the salary of the injured player during the period of inactivity. Furthermore, I'd also like to talk about the ACL injury. If you look at medical jurisprudence, you can find that ACL injury can happen over a period of time. It can also happen over a period of time. There need not be one specific instance that causes an ACL injury. Muscle tension building over time can also cause an ACL injury. So after this dispute arose, GFF conducted a separate medical test, and the records do not state definitely that the ACL injury was due to this particular incident, that is, Pedro Gonzalez playing for España against Germany. Thus, the fact that the ACL injury that caused Pedro Gonzalez's inactivity for over 9 months cannot be an isolated incident that took place at GFF's international match, and GFF cannot be the sole responsible body for this injury. The FIFA Club Protection Program also defines an accident as when it defines it as a football player suffers a bodily injury due to a sudden external force acting on their body. An accident can also be a specific sudden act of exertion at an identifiable time and place from which the football player suffers a bodily injury. Under this definition, Mr. Pedro Gonzalez is entitled to the insurance claim, but only to the extent of his injury, not anything additional to it. So I'd also bring the fact that BFC hired Pedro Gonzalez, and even they have a duty of care to check Mr. Gonzalez's fitness and medical fitness or overall fitness. And they also knew that Mr. Gonzalez was playing for Espana. So they also knew that there was an inherent risk involved. There was an inherent risk involved in that particular match of Espana against Germany as well. So the council, on behalf of the respondents, humbly submits that the GFF agrees to pay out Pedro Gonzalez's salary during the period of his recovery and is even willing to pay, as stated by Ms. Bella Salvatore. They are even willing to pay the medical expenses that are not covered under the player protection insurance. We want to pay the medical protection insurance because Pedro Gonzalez is an exceptional athlete who has consistently demonstrated excellence on the international stage, representing his country with skill and professionalism. However, the compensation for the loss of revenue from sponsorships and loss of ticket sales cannot be possibly covered under the player protection insurance.
Seeking the permission of arbitrators to proceed with the issue.
Yes.
Thank you. The next issue that is very much said by my respected advocate, that the liability of GFF, the due care. Yes, due care has been taken by the GFF, but there is a negligence on the part of GFF. The negligence has not only put our club at a competitive disadvantage, but also created an economic burden that we should not have shouldered. When the players are injured while representing their national teams, the governing body must bear the responsibility for ensuring that clubs are adequately compensated for their loss. According to Article 50 of the Swiss Code of Obligation, this article talks about how the multiple liability parties for damage that has been caused to the injured party by two or two more person, whether in the form of investigator, proprietor, or complicit, they are both jointly and severally liable to the injured party. In the current dispute, the allegations were levied against both GFF and the national medical team for the negligent behavior against the injured party, that is Pedro Gonzalez. Now, there was a point that was mentioned by my learned counsel that about the ACL torn being can be from a pass back. I agree totally that it is a medical jurisprudence that this phenomena can happen over the time of period. But I also like to point out there was a clause in the contract that was signed between my client and your client that physical background clause should be disclosed, as when a party is signing another party to play in their global football match, it is pertinent to know their fitness capacity, to what extent they can play or not, because ultimately all players are human beings and no one should be exhausted to the manner that they feel sick, or in this manner has such a severe ACL tone that they cannot play at all. They need rest for so long. Hence, I conclude my issues.
Thank you, Counsel. Do the parties have anything else to add to their arguments?
Honorable arbitrator, since the council included rebuttals, can the respondents too rebut for a few points that were raised by the claimants?
Yes, you may go ahead.
Okay. So we are not denying the fact that we will not compensate any of the losses that is being suffered. We are telling that we are agreeing that we'll compensate Mr. Gonzalez's salary for his period of inactivity. And we are even ready to bear the medical losses, despite that not being included in the player protection insurance. However, we are contending that we won't cover other losses like sponsorship losses, viewership losses, or ticket losses. And also, my learned counsel stated that, when Pedro Gonzalez, Mr. Gonzalez entered into an agreement with GFF. There had to be a kind of he had to reveal if there was ACL tear that was there beforehand, and I think he did. but there is no way that previous ACL tears are that evident that it can be that even they do show symptoms. It can happen over a period of time, and it can lead to a particular injury, and after that you get to know that there is an ACL tear, and that is the reason why GFF was unaware of the tear being existent in Mr. Pedro Gonzalez's body. That is all, respected arbitrator.
Thank you, counsel. Now I request the claimant and claimant counsel to give their closing statements.
Now, with the permission, thank you to the panel of arbitrators for the closing statement. In the closing statement, I would just include my portion of prayer that we have for this. Now, I do understand that there is obviously put forward this point to the vice chairperson of GFF and to the council of theirs that there is always a cost of replace. There is a cost that we brought Pedro Gonzalez for, and then now we have to replace him because we have certain competitions, certain international or domestic competitions that we are coming up, and it is obviously in our benefit that we participate in this. So for the goodwill, for our own club's goodwill in this various domestic and international competition, all I want is the GFF, if they could agree to at least cover the cost of the temporary replacement of our of a temporary player by either funding a loan deal or by contributing to the transfer or even contributing to the salary of that short-term player. And then also, I would like to point out that if they could provide Pedro Gonzalez with the access to world-class medical facilities and rehabilitation program, so that they could recover this, and they would act in that this would act in demonstration that the commitment that GFF holds for a player's well-being, and that would help my star player, that is Pedro Gonzalez, to expedite his return to the field. And as lastly, as rightly stated, that there is a FIFA program related to the club protection program that usually is an insurance policy of the injury risk of the national team player. I do understand your point on stating that you do not want to cover the sponsorship costs or the other costs related to that. So we are agreeing on one point that we would be asking for compensation that is stated in that of $7.5 million per player, as stated on the basis of the salary.
The
And lastly,
participants may note that you have 2 minutes left.
just it is a basic thing that I want to say. If it's possible to have a joint medical oversight to be developed to oversee the health and well-being of the players when they're participating in any of the international matches. Thank you to the panel of arbitrators. We are ending with a closing statements of praise.
Thank you. Respondents, you may give your closing statements.
Thank you, esteemed arbitrator. So, in light of the facts presented and based on the arguments and evidence submitted, the respondent, Global Football Federation, respectfully prays for the following reliefs: that the claims of the claimant, Blaugrana FC, be dismissed in their entirety as they are without merit and lack sufficient legal or factual basis to hold the respondent liable for the injury of Mr. Pedro Gonzalez. As we stated before, we are ready to cover the salary of Mr. Gonzalez for his period of inactivity and also his medical losses. But other elements such as sponsorship losses or even signing a replacement and the salary for the replacement player, it cannot be covered because the player protection insurance policy of the GFF does not have those elements. So when you don't have those elements, it will be difficult to indemnify it, and that is the reason it cannot be covered in in the player protection insurance. And the Court of Arbitration recognizes that the respondent has fully complied with the applicable FIFA regulations and his player protection insurance provisions, ensuring that all duties concerning player safety and insurance coverage were met. It also prays that the Court of Arbitration hold that the respondent is not liable for any of the indirect financial losses claimed by the claimant, including but not limited to sponsorship revenue, ticket sales, and competition bonuses, as these are not covered under the player protection insurance. The Court of Arbitration order the claimant to bear the costs of these arbitration proceedings, including the legal and administrative fees incurred by the respondent, that the Court of Arbitration grant any other relief it deems just and proper under the following circumstances.
The participants may note that your allotted time is over.
The allotted time for the session is over. Judges, with your kind permission, shall we move on to the feedback session?
Please. The feedback. What about traffic?
Yeah. Do you want the judges to speak now?
All the rapporteurs. Organizers,
Yes, sir.
you expect us to give the feedback or
Yes,
rapporteurs?
sir. Yes, sir. We need a feedback session.
Fine. Okay. Uh, we found an argumentative session here, right? Yes. We felt that it was more of an argumentative session where we felt that you were into an ADR session where people are looking at a kind of a consensual solution. Is that right? If that be so, we thought probably there would be more of, eliciting relevant facts which would make people think to an alternative solution that they would like to give. Here it has been very general that there is a claim, few of them are approved, few of them are not approved. But in an ADR, I believe that there would be a lot of other kind of solutions coming in. Now, we notice this as an arbitration session wherein the arbitrators are supposed to. One second. Find the arbitrators are supposed to. Yes, they didn't come out with. They didn't ask. I mean, they have to give their conclusion. I think the rapporteurs will give later on. They're supposed to give it now. Are not the rapporteurs supposed to give the session now? I mean, their opinion now or the award? The award. Organizers.
Sir, can you please repeat it once more?
Are the rapporteurs supposed to be giving their, verdict now or and then we come on to it? Wouldn't that be better? Hello, are we audible?
Yes, sir, you are.
See, the parties have now spoken, the lawyer has spoken, the parties have spoken. What about the rapporteurs?
No, the question is whether the rapporteurs will come out with their award now or you will do it later.
Yes,
Organizers
sir. The rapporteurs are to say it now.
Can we get 5 minutes to for me to talk to the other rapporteur and come up with an award?
Yes, then thereafter
Yes.
probably we'll have to give.
Once you give the award, then we will come out with our comments.
Otherwise, they would get some kind of a hint from our side, which I don't want to. That's the reason. Okay.
Yes, sir. Just give us 5 minutes.
Yeah. Yes. Are you ready?
Yes, sir.
We are here.
Yeah. Thank you for both the parties for a very fruitful and
because, ma'am, why we said this is because we are supposed to, assess the rapporteurs
Yes, sir.
also. Suppose we
Yes, sir.
make some kind of a mention, that would influence them. Probably, that's the reason. In fact, let them also finish their roles and then we will come back. Okay.
Yes, sir. May I go ahead?
Please.
Yeah, I would like to start by thanking both the parties for a fruitful session. You have maintained the decorum and all the rules and regulations, and also for agreeing to come to arbitration, as we all know, which is a speedy resolution forum. So thank you for choosing this dispute resolution method. We have both my co-arbitrator and myself have assessed the arguments of both the parties, and as an award, we would like to state that both the parties have given your legal backings, and the issues was about regarding negligence of the national team and the liability that must be held by GFF. So the award goes as the Global Football Federation, which had an agreement with the Bloggerna FC team club has because of the contract that was already there. There is no they cannot cover indemnity regarding any other things other than first the salary of the of Pedro Gonzalez, the injured party, during his absence. Second, as the respondents themselves stated, the medical expenses of Pedro Gonzalez. I would like the co-arbitrator to continue.
So yes, the award would be like the GFF would be paying the salary due to the absence or due to the recovery of Pedro Gonzalez, that is the period of inactivity, and will also be paying the medical expenses as agreed by them.
Further, in consequence of the fact that Pedro Gonzalez was a very esteemed player who is important to the FIFA or the football club, we are awarding for a temporary that the GFF pay the temporary replacement to the claimants, to the Bloggerna FC club. But any other indemnities are not covered. No coverage of tickets and other expenses that were occurred to the claimants. So the final award is that the GFF pay the salary during the absence of Pedro Gonzalez, the medical expenses, and the charge or the cost for temporary replacement.
So the temporary replacement amount would be 5.5 billion as such.
Judges, am I audible to you?
Yes.
Judges, you may give your feedbacks now.
Yeah, now it's okay, fine. See, what we have probably noticed is that this is not a typical arbitration, but this is where people have come forward to resolve through arbitration. However, going by the award that we see, there is something that we see as missing. And that missing element is the distinctive difference in this kind of an ADR compared to that of a very formal arbitration. And what is that missing one? There are no reasoning given by the arbitrator in this. And what has ultimately come in is certain clauses which says so-and-so shall do something to the other person, and it's just the last final, directive as to what is to be done. This makes it. This is what actually makes an arbitration different from this kind of an ADR. The way the organizers have schematized this particular program. It's in a way. Now, this kind of a resolution, when it is agreed to by the parties voluntarily, then that takes it out of arbitration and it comes into something called the conciliatory mode, which is either a mediated, settlement or a conciliator settlement. Now, the way the organizers have organized this, or the way they have brought in a new concept, is that parties are asked to, bring in all their arguments. Also, very, very voluntarily say to what extent they can go in concede. Unlike in the normal arbitration where everybody would be contesting without any compromise, or unlike in a mediation where, they would certainly put it in such a way that, they try to, bargain whatever is available, subject to the other side approval. Now, here what I have seen is, yes, the parties have literally put in their, case. Lawyers have also tried to convince the other side as to why they have a good reason. And the other side have also tried to understand it. But what probably was missing is that kind of a submission where the other side sympathizes or they understand your situation and then they concede. Now here you have seen the negligence as an issue. Am I right? Negligence as an issue. And is that only the issue? Is also yet another one, probably because you're all young and probably the three of us may find a few more issues which are involved in this. Fine, that we are not going to disclose it now. There are a few more issues which might come up in this particular issue, this particular case. Second part is, see, in the conciliatory mode, the rapporteur also has, the neutral rapporteur also has certain kind of, further involvement. The role is also a little different. The role, when I say the role is different, they have a role to make the people think in slightly a different manner than looking at what is asked and what can be given. Not directly, something being asked and something being given. But in these kind of conciliatory modalities, there's something like an alternative to the regular solutions that you find is also one thing. So more like a conciliator and a mediator, they find out solutions which are not the straight-jacket at once, for which you have to interact with the parties, which is something which I found missing with the rapporteurs, in fact. Mediation, skills that you have, or the conciliatory skill that normally a person is supposed to have in this kind of a setup. I did not find something called, I'm not sure, if you're trained in that, or if you are being briefed about it. There's something called restating. That is, you listen to something and then you show that, okay, you have understood it so well, and try to restate it in such a way that nothing offensive actually goes to the other side, and you try to, say, had it been thought this way, had it been seen this way, what would be your reaction? So you try to make them think in a different angle without telling that you are actually, violating your neutrality or this is what you believe. You see them as possible ways of, resolving an issue. There are so many techniques which maybe being young, you're all amateurs, probably you're yet to get into those kind of techniques as conciliators or mediators. That was probably something more missing. Why I say this is because even if a team feels they have won, please don't stop at that. Yes, you have won with 40% achievement. In this particular skill, there is a little more, another 60% yet to be trained. And had you got trained in that, you would have been much, much more wonderful. So winning a particular side, winning this particular competition does not, should not make you feel that, okay, you have been wonderful. You have been wonderful to the extent of, having presented to the extent that a young professional or a professional student can do. And to that extent, you have done wonderfully well. So what I suggest is, these competitions are exercises for you. And these exercises are to develop or improve your skills. And there are much more to be improved. much more skills to be achieved, achieved by you. That is something which you will have to keep in mind. But to the extent that you have done, it is perfectly fine. And one more thing, when you see in these kind of sessions, they are never into argumentative mode. Please listen to this, just, somebody who has been experienced just telling you so that, you also gain something. It is never, the statements or submissions are never in argumentative mode. Fine. The moment you start arguing, the other person is not going to listen to you. They're going to create some kind of a barrier. Now here there is something that you wanted to say, more than you wanted to respond to what they say. So if you have to respond with some kind of a solution to something that they say, your probably statements will have to be a little more slower, in such a way that you make sure that the other side understands your innovative concepts or innovative solutions that you make. Here, you're just talking about an insurance cover, whatever is available under the insurance cover and little more. And it's good. One thing that I notice is that you have gone a little further to agree as to what you can give. Am I right? Even if you don't have to give a salary under the strict, the scheme, you have still come forward to give something more than what you need to give. That certainly, qualifies you to the first part of it, where somebody who has come, like your objective that you mentioned, you are here not to fight. You are here to see that, somebody else's needs are also looked into. And you would like to have something like a conciliatory kind of a solution, to which, you certainly volunteer to do something more, or you also make the other people feel that they have gained a little more without you losing much. So to this extent, probably I'll leave it to others, if they would like to mention.
Well, I'd like to add to what Mr. Srilal Varia said. And I would also like to add my words of congratulations to all the participants. They've done very well. The only thing is that probably we are also a little confused as to what was the actual process. Was it was it mediation? Was it arbitration? Was it a combination of the two? Anyway, what worked out is, I think, it is the participants were no doubt argumentative. They raised legal points. With the legal points they raised were no doubt interesting and relevant. But I thought a few more points could be culled out. Like, for instance, is there a jurisdiction at all? Whether the court for sports has jurisdiction at all? Some party could have opposed, saying that, okay, where is the jurisdiction? But here we see both the parties, okay, they agree. Now, apart from the two parties, the club and the GFF, there is also a third party, which is the state of España. And that also should have been brought in. Whether España should have been joined in as one of the necessary parties, that is an important question. Why could you not also claim damages against España? And also there is one very important question. Why did the club not have an insurance policy of its own? Why is the club asking for the insurance from GFF? So these are all some of the questions that could have been raised by the parties on the argumentative side. But now we saw that, okay, the parties have now compromised, and they have, from the beginning, the GFF side was saying on as to what is it that they're going to concede. And they stuck to those points that they thought from the beginning that we are going to concede on this. On the whole, I think it was a wonderful exercise, and I congratulate the team members. And as Mr. Srilal was saying, I also felt that the reporters could have intervened more to bring out certain. They could have asked questions at the right time, or they could have asked more. And one more point here, as Mr. Srilal also said, that be slow in your arguments. You don't have to raise all the points. Take 2 or 3 crucial points, explain those points. Need not cover everything. But also, it should not seem to us that you're just reading what is the material in front of you. You argue your case. That is, and it should come. The word should come from with knowledge and from your heart. So these are the points that I would like to make. Thank you very much.
Will I just add something like, had it been a real life scenario, this arbitration would have been a multi-million arbitration where the arbitrators and the councils will be coming in private jets. Of course, we had a small slice of that arbitration happening here today. Sports arbitrations worldwide are conducted that way. Anyways, India is a country where we don't have a uniform rule for the conduct of arbitration. So the responsibility of the arbitrators to control the arbitration is huge. Well, this can be a stepping stone for all of you to, go miles in this area of arbitration. Wish you all the best. Thank you.
Just one thing to add. Now, the whole difference between the regular arbitration is what an arbitrator can give under law. But in these kind of, the earlier session where you are more into negotiations and, readiness to give up something and take something which is not otherwise what is exactly under law. Those innovative solutions are more expected in these kind of sessions. Hope you're getting my point. If the rapporteurs are supposed to give an award in recognition of what parties have agreed, then it is more like a mediation or mediator settlement being recognized by the rapporteur and they're giving an award. But if the rapporteurs are supposed to give something as an award, like in arbitration, then it exactly as under the law, what they can actually give. This distinction should go into your mind, and that's all. I mean, the difference is basically this. One is exactly as per law. The other one is very flexible, which can be innovative ways of compensating. For one simple example is maybe the association could have said, yes, we would waive the fees if at all there is anything, because you probably cannot be doing much this time because of your team is disrupted. Certain things, like that's just one thing. There could be hundreds of innovative solutions. These kind of out of the box thinking and innovative solutions are the products in the first stage negotiation kind of or conciliatory modality. Thank you. Wonderful. Wish you all the best in your professional career. Okay. Hope to see you in the bar. Bye.
Thank you, judges, for your valuable feedbacks. With this, we have come to the end of the session. I'd like to extend my sincere gratitude to the judges and the participants for their kind cooperation. Now, you may leave the meeting. Thank you, judges.
Thank you, judges. Thank you.
Thank you, judges.
Thank you, judges.
Thank you all. Wonderful participation. Fine.
Thank you, sir.
Thank you, sir. Thank you so much, sir.
Thank you, sir.